On the 31st of March, 17 separate American court decisions all flagged the same problem. 17, in a single day. And every one of them was a legal filing that cited cases which simply do not exist. And these were not vague. They had names and volume numbers and page numbers and judges who supposedly wrote them. None of them were real. Not one of the 17. Every detail was invented, and every detail was plausible. Now nobody attacked those firms. There was no breach, no malware, no stolen credentials. The software worked exactly as designed. Before you file this under a lawyer problem, stay with me, because lawyers are the control group here, not the subject. Checking your sources is not one step in that profession. It is the profession. It is what the job is. So if verification is failing there, it is already failing in your organization too. Earlier this year in Cincinnati, the Sixth Circuit fined 2 attorneys $30,000 between them over 24 fake citations and misrepresentations of fact in one set of briefs. That is the court's own count. And the judges called it a conservative estimate, $15,000 each. The other side's legal fees and double costs on top, all of it, because a machine sounded certain and nobody opened the citations to check. Now, you have almost certainly heard this called hallucination. NIST calls it confabulation. It sits in the generative AI profile. AI 600-1 final, July 2024. Risk number 2 of 12. And NIST's definition is the whole problem in one line, confidently stated but erroneous or false content. And note the word NIST chose there, confidently. Here's what makes this different from every other threat we have covered in this series. Poisoning had an attacker. Theft had an attacker. The supply chain had an attacker you could eventually name. This one has nobody. Nothing broke in. Nothing was compromised. Nothing was even misconfigured. Because a language model does not look a fact up and hand it to you. It predicts the next piece of text. A true sentence and a false one are assembled by exactly the same machinery out of exactly the same maths. Nothing inside the model separates them. There is no internal signal that says, I am guessing now, which means there is no version number that fixes this. NIST lists 12 generative AI risks. This episode is about 2 of them, not because they are the worst, because they compound each other. The first one is the machine being confident. The second one is us believing it. And of the 2, the one that nobody budgets for is us. The model is confident. The organization is responsible. Every one of those 17 filings passed through a person before it reached a judge. The person was the control, and the control did not fire. So if the machine cannot check itself, the control has to be a person. NIST has a category for that too. Number 7, human AI configuration, which is NIST's term for a badly designed relationship between a person and a model. NIST names 5, anthropomorphism, aversion, automation bias, over-reliance, emotional entanglement. There is a 6th NIST does not name. It is the one I would write down, unclear authority, because that decision, what an AI output actually is, almost never gets made at all. Is it a draft, a suggestion, an answer, a decision that has already been taken? In most organizations, nobody has ever said, so the output borrows its authority from whoever forwards it. And every time it is passed on, it arrives sounding more settled. By the 4th desk, it is not a suggestion anymore. It is just what we know. Nothing was added along the way. Only confidence. And before you file this as a courtroom problem, that same chain is a vendor questionnaire, a board summary, a number in a deck. You can even ask it outright whether it is sure. It will tell you that it is, and then hand you the same invention again. Which brings us to the only question a board actually asks about any of this. If the machine is wrong, who pays? In 2022, a man in Canada booked a flight to his grandmother's funeral. The airline's chatbot told him he could book now and claim the bereavement discount afterwards. That policy did not exist. The chatbot had invented it in full sentences on the company's own website. He booked the flight. He claimed the discount. The airline refused, and he took it to a tribunal. And Air Canada argued that his chatbot was a separate legal entity, responsible, they said, for its own actions. In 2024, the tribunal did not accept that for a single moment. Air Canada was responsible for all of the information on its own website, whether it came from a static page or from a chatbot. The damages came to $812.02. The number is small. The ruling is not, because what that tribunal settled was not a refund. It was the question of who is speaking when your AI speaks. Your model's confident invention is your company's statement, and the AI risk management framework already has a name for that: accountable and transparent, clear responsibility for outcomes, which is what the tribunal said, in considerably fewer words and with a bill attached. And before anyone asks, no, none of this certifies you. There is no AI certification to go and pass. These frameworks are voluntary. That is not the same thing as optional. Air Canada did not lose on a framework, it lost on responsibility. So what do you actually do about a failure mode that has no patch and no attacker to block? 3 things. And the good news is you do not have to invent any of them, because NIST names all 3. 1. A human in the loop on consequential decisions. Not every decision. You will never staff that, and honestly, you should not try. Consequential means one of 3 things. It leaves the building, it binds you legally, or it is expensive to undo. A court filing, a price you quote a customer, a clinical note, a line of code that ships. If it leaves the building, a person signs it. 2. A verification workflow. And this is the one that everybody thinks they already have. Every single sanctioned lawyer in that database did the same one thing. They signed a citation they had never opened. Verification is not the same as being careful. Careful is a mood. It is not a control. A control is a step, with somebody's name on it, that the work is not able to route around. A control that someone can skip is not a control. 3. Say out loud what the output is and what it is not. Declare its authority before anyone acts on it. Remember those 4 questions nobody had answered? Answer one of them in writing. It is a draft. And that is the gap in Category 7 closed. Unclear authority made clear. 3 moves. A signature, a checkpoint, and 1 sentence written down. Underneath all 3 of them, the same framework. AI 100-1. Valid and reliable. Accountable and transparent. And every one of them comes down in the end to a person who can be named. Not a policy document. Not a training module. Not an acceptable use page nobody has read. A name. Because when it is wrong, and it is going to be wrong, it will be wrong in your company's name. So here is the one thing to do this week. List the decisions that leave your building. Beside every one of them, put the name of the person who checks it before it goes. Then write down in 1 sentence what the AI output is allowed to be. That is the whole control. 3 lines on 1 page. And it is the only version of this that survives contact with a genuinely confident machine. 17 court decisions in a single day, and those are only the ones we can see. Next time, we point the same technology the other way. AI that defends you at machine speed, and the human oversight that keeps it honest. That is episode 10.